Right, it says that you're supposed to, I don't know, I don't even
Take
know.
reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
$1:50
in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty.
Here's the tricky part. The law says you must take reasonable steps to notify the property owner if you cause damage. But what counts as reasonable at 2 a.m.? Knock on the door and risk scaring someone or leave a note and hope they see it. What would you do if you hit a mailbox in the middle of the night?
Easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the,
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I would see,
I
and then I would
guess
see
there
a
are
crashed car.
there are other measures I guess you could take theoretically,
Do something, some
Right.
right? I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would. Have you run his license, see if he has a valid Texas driver license?
It's
Mr.
an out-of-state Florida license that appears valid in our system.
Okay, Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay, you've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Famine. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge, just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
Do you guys have insurance? Can you rip the CW and
Yes.
then we can settle it?
You did have insurance,
Yes.
hopefully.
Yes, sir.
Okay, wonderful, great. Okay, all right, man. Take care, have fun. Can you file that? Do you mind those conditions? All right. Michael, he still needs to sign the conditions and then he can go.
Yes, sir.
Okay, so just, sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28th, 2024, the officer came to a stop behind the defendant's vehicle and the light turned green and the defendant's motor vehicle proceeded and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes.
Whoa, 0.192? That's more than double the legal limit. For context, anything over .08 is considered intoxicated in Texas. Judges crack down hard here, especially on repeat DWIs. But here's a question: do you think license restrictions like interlock devices actually stop people from drinking and driving again, or do they just find ways around it?
Steadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right, how many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel and he'll tell you when you have to come back. You understand?
So I need to wait for him now.
We're gonna have you wait for him now, but after today, I'm gonna waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right, I'm gonna have you sign a reset. I'll have you meet with Felicia for bond conditions and we'll just have you waiting back for Mr. Stewart to show, okay? Please. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a disturbance at a residence in Harris County, Texas. And the complainant, the mother of the defendant, told officers that the night before, her and the defendant had gotten into an argument. The defendant returned the next day to get his belongings, and the defendant walked up to the complainant with a fighting stance. And the complainant told officers that the defendant grabbed her wrist, causing pain and scratches and attempting to pull her. The defendant stated, "No, bitch, you're coming downstairs with me." The complainant pulled away and the defendant then slapped her in the face, causing pain. The witness, the defendant's sister, also saw the assault.
Mr. Brunson, I'm going to find that there's probable cause to go forward with your case. No, now's not the time. You will have the opportunity. Now's not the time. I'm just trying to find if there's enough probable cause to go forward. If so, what kind of conditions to put on your case, if any? Have you reached out to the complaining witness? Do we know what she wants?
So we made an attempt and she couldn't speak to us at the time we called, so we'd have to reach out.
Okay. Mr. Brunson,
That line, the capital murder of misdemeanors, is chilling. Protective orders are no joke, because violating one can instantly escalate charges and land someone back in jail. This case shifts from reckless driving and DWI into the emotional world of domestic assault, where the stakes aren't just legal, they're deeply personal. Stay tuned, because the tension only rises from here.
because I always like to follow the wish. Stop. Letting you know what the expectation is in this court. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to sit there and type it and use it against you. I like to follow the wishes of the complaining witness. When I don't know what they want, I'm going to order you not to have any contact with them. I'm also ordering you not to be in possession of any weapons as well. There is a protective order that has been issued in this case, and if I were you, I would get to know it, because if you violate the protective order, the state can and will file additional cases against you, including a violation of protective order, and that is the capital murder of misdemeanors. Do you understand? So get to know it. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria and sign a reset. We will have you take a seat in the jury box while we get your bond conditions ready, while we sign it. And after that, you'll be free to go. All right, please.